matter for me, please.
Application for leave to appeal, criminal appeal number 25 of 2016, Cecil, Moore, and the King.
Yes, Mr. Fletcher. Thank you all for your indulgence.
You're welcome.
Yes.
The representation remains the same.
Yes.
Would the court like me to repeat the names?
No, you don't have to. No, you don't have to.
Thank you very much.
We're just not seeing the okay. Yes, Ms. Edwards.
The learner director, Ms. Lulin, Ms. Council, and Ms. Togwell, I hold for them. They will be arriving late, Millards, and I apologize on their behalf.
Okay. Thank you. Here they are. Ms. Togwell, at least.
Thank you, ma'am. The court will recall that yesterday our submissions is the panel hearing me? That I have been making the point that the unevenness in the practice of crediting pretrial remand may have been because of the view that the legislation and the common law was in conflict. And I made the view, I made the point that none of these things were really taking the Charter of Rights into account, and that once the Charter of Rights was taken into account, then it was a different game change, because the Offences Against the Persons Act is not equal to the Constitution. It is in that context that I considered how the Canadians have tried to deal with this matter, the issue of the conflict. And in that regard, I read Worst. Worst is interesting for several reasons. The copy that I have in the bundle, it's at volume, it's at tab 11. The fewest of third form French words recognized. And this is a matter in which the accused, do you think, Madam President, that I need to go through the facts of Worst?
I think it would assist the background.
Thank you very much. The accused had pleaded guilty to charges of robbery with a firearm and possession of a restricted weapon. At the time of his sentencing, he had been in custody since his arrest approximately 7.5 months earlier. And he was sentenced to 4.5 years imprisonment with a concurrent 1-year term for possession of a restricted weapon and was credited 1 year for his pre-sentencing custody. The resulting sentence was 3.5 years. The Crown appealed the sentence, seeking to have it increased to 7 or 8 years. The Court of Appeal had varied the sentence, and that is why it came before the top court as an appeal against that variation. May I just say, right from the start, that for me and my learned friend, Worst is instructive for two main reasons.
Sorry, before we go into how instructive, you didn't give us what the Supreme Court concluded, just for the decision of the court that you'll be relying on.
They allowed the appeal, man.
So they restored the sentence with the reduction.
Yes, ma'am.
Yes.
See, the appeal should be allowed. Why are you muttering things to me when I speak, boy? And two things. There is a very lengthy exposition of alternatives that have been applied in the Canadian courts to get around situations where there is a mandatory minimum in some piece of legislation and credit is to be given for time spent in custody. It's interesting because it may raise options for us. But the most important thing to us is the concept of reconciliation. How the Canadian court decided that the two pieces of legislation which seemed to have been in conflict were reconciled by the use of tools of statutory interpretation. At the end of the day, using the rule of purposive interpretation, concluded that the intention of Parliament was not to be in conflict in the two pieces of legislation. Could I refer the court to paragraph 9, the English version,
Mr. Fletcher, before you reach 9, I don't think we can overlook the introduction itself, which shows you why this matter is so useful to us within the confines of our legislation. Yes. We have one legislation. They have several which they have to.
That's paragraph 1.
If you look at the very issue, this is the issue that I think confronts us. Whether when Parliament has imposed a mandatory minimum sentence, the courts made it up from that sentence, the time spent by the accused in custody while awaiting trial and sentence. If this has the effect of reducing, it reduces the sentence pronounced by the court to less than the minimum prescribed by law. That is the issue that
Yes.
so it's-
Yes, my
and
lady.
the way they describe it, a legal issue of deceptive simplicity,
Yes.
which is similar to, which is what we have
Well,
recognized.
well, it would be an excellent way to describe what we have been going through. Because when our judges come down on one side or the other, they are sincere and clear. So that's why that phrase is apt. I was going to come to it, but what I wanted to do first, which is why I went to paragraph 9 first, my lady, is to give the court an idea of which enactments which were in conflict. Paragraph 9, it says, it states again, the task before this court is to settle the controversy regarding whether or not section 719 subsection 3 may be applied to sentences imposed under section 344A, by implication to mandatory minimum sentences. So it was section 344A, which allowed for the imposition of the mandatory minimum, and section 7193, which allowed the time for the credit. And they were in controversy, the word being used here. And and that is why, my lady Williams, it then comes to one is a much more summary description of what is here at 9. And I'd like to, so there is 344 and 719, those are the things that were in conflict. And that is why, if you would indulge me and go to paragraph 18 of the sentence, of the judgment, from there on, from 18 to 21, that is where there is an exposition on how the courts have dealt variously the different cases. For example, in 20 they say, in other cases, courts have fashioned the remedy of a constitutional exemption from a mandatory, a range of things.
But it's been seen 19 where they said in some cases they have been struck down,
That is right. That is right.
which we know how the Privy Council has viewed.
So that's the range of things. But this is where I'm coming to the point about reconciliation. Because at 22, the French and the English is confusing me as to which side the numbers are on. It's very basic. Deceptive simplicity.
Interest, and it might be of interest when we look at the Attorney General's submissions. It's in paragraph 19, where it says that in some cases the courts have fashioned the remedy of a constitutional exemption, thereby upholding the enactment itself as valid, while exempting the accused from its 20?
Yes.
20?
That is the reconciliation.
Oh, sorry, from its application. And this is what our Privy Council said in Tafari Morrison,
Yes.
that once, even with a minimum,
Yes.
the court can go under it because if it is grossly disproportionate. So the Constitution can be used
Yes.
to
Milady.
disapply the And I think it goes on here, right? This is a critical question. Finally, in some of the cases where the courts have upheld a minimum sentence as constitutionally valid, it has been noted that the mandatory minimum was demonstrably unfit
Yes.
or harsh in the case before the court, which would be what is the proportionality, is the test.
Proportionality. That's what I call in the round the reconciliation.
The only thing is that our reconciliation is not between two statutory provisions, as
But
Justice
but
Harris pointed out.
that is
yesterday.
exactly my point.
What is the place of the Constitution
I'm
in
just
it?
showing that we have these
Yes.
two equal enactments in a sense. The court is still able to reconcile by using statutory interpretation rules. May I refer the court to paragraph 23? Three. On the left.
No, my sister had asked if you'd want to highlight 22 as well.
Yes, ma'am. But I just want to read 23 first.
Okay, nothing. Yes. Go ahead.
In accordance with the umbrella principle of statutory interpretation expressed by this court, that was another case, Rizzo and Rizzo Shoes, mandatory minimum sentences must be understood in the full context of the sentencing scheme. It goes on to talk about the classical principles of sentencing as part of the Canadian scheme, such as rehabilitation, specific deterrence, public safety, restoration, and so on. They use much more words than we do. So that the court are there insisting that the enactments must be interpreted consistent with the sentencing scheme, the classic principles. And that is how they were able to, at one and the same time, say, yes, that section which insists that the mandatory minimum must be given is sound because it is purposive. It actually is to, apart from prevention, send a message that if you commit this type of offense, this is the minimum you're going to get, and it's a long period of time. But at the same time, it can't be purposive to deny giving credit for somebody who has been in pre-trial custody and not under sentence. Not under sentence at all.
Mr. Fletcher, I always think it's better to say pre-sentence than pre-trial because sometimes things happen between trial and sentence which actually extend the time that the person is in custody before actual sentencing.
Well, I beg your pardon, my Lord Fraser. In reading was, I was not convinced that that is a part of our sentencing regime when I read it. And I know that my learned friend the director likes to use cricketing imagery. At the time that I was studying it, I just left that ball alone. Yes. And confining myself to time in custody before the trial. Of course, my lord, it is of course open to the court en banc to deal with any other and bring in any other collateral matter that it wishes and that it sees as apposite.
I think Worcester itself says pre-sentence, but anyway.
And
Yes, I think, yes, I think it's a term, an umbrella term that the court chose. And I think some options that they had was like, what, daytime, and they just chose that. But it is important because in their jurisdiction, there are cases and that deal with only pre-sentencing alone.
All right, since you seem to like this case so much and rely so heavily on it, perhaps paragraph 29 would assist, because in paragraph 29 the court refers to the various nomenclatures.
Yes.
Speaks to pre-sentence in custody, pre-trial custody, predisposition custody, and dead time.
Yes.
And says these are all used to refer to the entire time spent by an accused person in detention prior to conviction and sentencing. And for the purposes of this decision, I consider all these terms to refer to the same thing.
Yes.
However, and the particular judge says, I prefer pre-sentence in custody as it most accurately captures all the time an offender may have spent in custody prior to the imposition of his sentence.
Yes.
Okay?
Yes. Well, thank you very much, my lady.
You're welcome.
I actually feel like a hurdler that is not quite fit because I intended to jump several hurdles to reach here, but your wonder is, man. The wonder is. Yes, ma'am, that is it. So I want to just come back to the point that I find I called it the reconciling to be a very probably the most interesting part of Worst. And may I say why I think so, and of course, naturally it is up to the panel to think that I am offline. But it appears to me, Madam President and members of the panel, that there might always be some kind of lurking suspicion that a judgment that you write intends to assail the offenses against the person's act. By reconciling, that suspicion is dead. By indicating, if it reaches there, that there is really no inherent conflict, because one intended that and the other one could not intend to breach the Charter of the Fundamental Rights. That is the end of how is it described here? Controversy.
So you apply that to our local condition now and give us a submission.
You would like me to give you a statement.
As your submission. Sorry. Yes.
Can I have 5 seconds? Just 5 seconds. Yes.
We just wanted to fit it in the context of Wolves, given our own
Yes.
local conditions,
Ye-
which are
ye-
not quite the same.
Yes.
So just help us out.
Yes,
What
yes,
you want
yes,
us
my
to
lady.
say.
It's not the first time that I'm being asked to put together a set of words that could represent what I'm never really ever successful at it, but I'll try again. I'll try again.
Is that the problem?
Yes,
you
I
thought
think-
that you had done it
I-
a while ago.
Yes, and
I see.
my lady, first up, you notice how that I slowed down.
Ah,
And I thought that when I slowed down, this was in fact the paradigm, but obviously not.
oh,
They-
I see.
they-
Specificity.
The problem is, Mr. Fletcher, is that WUS is reconciling to clear,
Exactly.
clear legislation, the Constitution and the legislation, which clearly gives the court the power
Yes.
to do something.
Exactly.
Whereas in our context, there's no legislation that gives us that power.
Yes.
So that is why the level of reconciliation that you're wanting to apply cannot apply in our context.
It has to be modified.
It has to be
somewhat.
modified, and I suspect that is why the president is asking you now to bring that lofty and profound statement that you just made in relation to the Canadian context
Yes.
to our context. We have the Constitution, which says this, and we have the law, which says
One statute.
one statute that says he must get minimum of 15
And we have the
years.
common law.
And we have the common, still
That
have the, we
says-
still have the common law.
So my sister said it more beautifully than I could.
Yes, ma'am.
But that's the help we need, because
So-
we are not dealing with the two statutory provisions. We have a common law position that has developed from judge-made law, if we call it
Judgment,
that.
right.
And then we have the statute common law saying give credit, statute saying minimum sentence, and those two, if we are to give credit, it has implication over here for the statute.
Yes, ma'am.
Woods didn't have that sort of setting. Woods had two. So what did Woods use to reconcile them? So you have to give us what we must use to reconcile. You made a statement, you said the end of the controversy, if one statute is in conflict with the Constitution, but you have to bring it home to us and say what we would have to find to be so. That's why I found it a bit loose in the end, left hanging. So
Well,
just
ma'am, I
formulate your thing, your
Yes,
final
yes, ma'am.
thought.
I come from a tradition where I am prepared to fall but never yield.
I won't say a word.
As is my friend here.
I have to
Right.
restrain my brother while he restrains himself. He says.
But I'm going to try, man.
Yes, thank you. Just
If you'd
give
allow
us
me.
something to work with.
Yes, ma'am.
Yes.
Failure, and I start with that word, and I'm very conscious of my linguistic competence because I know I will be corrected easily, but this is a sentence that starts with a capital F. Failure to grant credit for time spent on remand in pretrial custody may be a breach of the Charter of Rights in relation to Section 13(3)(a). It is not, new sentence. I'm sorry, no. There's a full stop. It is not inherently contradictory of the Offences Against Persons Act which stipulates that the minimum mandatory must be given for certain type of offenses. Because a purposive interpretation of the Offenses Against the Persons Act grounds the minimum sentences, and that's a fact. But the Offenses Against the Persons Act cannot at the same time be purposive to deprive a citizen of credit for time spent in pre-trial remand when he has not been convicted.
Because of Section 13(3)(a)
Because of Section 13.
of the Constitution.
And Mr. Fletcher, we would agree that the section itself in the OAPA did not specifically indicate that you would not get the credit.
That is very important. So there's an asset. The silence is significant. Put it that way. The silence. In other words, you could have said they must not get. That's what I mean. No exemption. As the Canadian
That
found in rules.
344A did not make any exemptions
not
of
make any
7193, correct?
Yes. Whether intentionally
What do we
or
call
not.
it again?
Whether intentionally
I
or
don't
not.
think they had given thought to it.
No, man.
Because the common law principle emanated in our jurisdiction 2016.
Yes.
So they didn't give thought.
I remember something in my memory about how when the court is interpreting certain sections, that one of the first things we are to do is to ensure, in our interpretation, is to interpret it in such a way, firstly, if we can,
That's
that there's
positive.
no conflict with the charter,
Well, not
the
only that,
Constitution.
there's also a sub-provision which says, I think it is in hearing rules, that it ought to be interpreted
To give effect,
positively
Correct.
to the person,
to give effect to,
To
the
give
right.
effect
give effect to the right.
To the rights, correct.
And our charter expressly says
Yes.
no organ of the state
Yes.
should breach any of the rights enshrined, except if it is
is
demonstrably
demonstrable.
justified
Yes.
Justified in a
free and
democratic
Well-
democratic society.
My lady
So,
President and
we have
members
a
of the
lot to
panel,
pick.
of course, at tab 5,
He gave it. 42. One second, Mr. Fletcher. My sister Justice Edwards pointing to another paragraph of WUS that could assist us. Yes, and 42 seems very important, and I think the WUS analysis, some of the cases also draw on the equal treatment of offenders to say that an offender on bail, given the statutory minimum, will fare better than an offender, given the statutory minimum, who has been in custody. So he said, even though the court intends to give him the minimum of 15, because he was in custody, with no credit, he's going to serve more time than the one on bail. So they
Yes.
draw on the equal treatment
Yes, ma'am.
right as well.
Well,
I think at 42, if you could just
yes.
look at that.
If this court were to conclude that, pardon me, my junior is muttering significantly. May I just have a minute? I'm grateful to
And
you.
you have to listen to your judge.
Yes, always,
Yes,
ma'am.
always. Yes.
The 42, if this court were to conclude that the discretion provided by section 719 to consider pre-sentence in custody was not applicable to the stat mandatory minimum sentence of 344A, it is certain that unjust sentences would result.
Yeah.
The thing about worst, and indeed, even though I am not right now citing the other cases that are mentioned, MacDonald and so on, a lot of what might appear to be collateral important issues are always traveling parallel to the narrow central issue that we're talking about. Unjustness, unfairness, and so on. It's never just a straight, pure line. So here it is that the court is now, Arbor is now talking about
The 9 of them.
the unjustness of doing that, which in our discussion so far have been implicit, that is implicitly unjust. That you could not be the author, for example, of the length of time that you have to wait for in custody for a trial, and still is almost being double punished. I mean, of course, because of the allegation that you did the act, that is why you were arrested. And I guess the ordinary citizen would take that very popular view. But it's not your fault that you have been waiting all of this time. You can't be punished for it. It's unjust.
Is the entire 42?
I didn't read the entire 42.
No, I'm just saying the entire 42 gives us room for
Yes.
thought, food for thought.
Yes. Madam President and your members, may I just say,
Well, you know what I'm looking at too with interest is that it took 7 judges out of 9 for the Supreme Court of Canada to determine what seemed to be a simple question.
deceptive.
Just
you say.
it is deceptive in its simplicity,
Yes.
and that for persons to understand why we are sitting here over this. But it's a very important question in our jurisprudence
Yes.
because of the conditions under which we keep our prisoners and how long our cases come up for trial.
Yes.
The court has to pay attention to this. We have
Yes.
too many cases from our own court where we have to give remedy for delay
Yes.
because we breach people's right to trial. So
Yes.
we have to focus on it. So it is 7 judges in Canada
Yes.
and they have legislation.
Yes.
But yes,
But what I also
we'll just
found
highlight 42.
interesting, Madam President, is how different courts ruled different things
Yes.
on the same question, and that was explored, in the judgment.
Yes.
Yes.
One court of appeal ruled A, another court of
Exactly.
appeal ruled B, and then there was a case when a judge actually overruled himself.
Exactly. So
And I just think that goes to show the place that there is for different views
Yes.
on significant matters.
Yes.
Yes, and that's why you shouldn't be afraid to bring points forward, even if it seems as if the legislation is against you.
Thank you for that.
Yes.
Your retired sister, what's her name?
Several.
Justice Hillary Phillips
Oh, wow. Recently retired too.
made that point to me once before, that it is the duty of the advocate to unashamedly put the thing before the court.
But the good thing is that the highest court settled the question. So after the Supreme Court of Canada ruled, That is to get rid of all of that controversy.
Yes.
That is why it reached there.
Yes.
So that is the issue. Once the final court rules on it, it doesn't matter our views. If this goes to the Privy Council and it rules against our ruling, we are stuck with that and we have to live with that.
Yes.
So that is why we have highest courts.
Yes.
So it is good that an issue like this have reached one of
Here.
the highest courts in the Commonwealth.
Yes. Well, ma'am.
And Justice Witt in the CCJ case, he showed you the extent of the inquisition of that question
Yes.
all over the globe.
Yes.
So it has always been a question that troubles the jurisprudence, but it is
Yes.
good when the highest court deals with it.
Yes.
So
Well,
that is why.
may I just say that
Yes.
that when I started reading Worst, I thought I was in a desert.
That's how the Canadians do it.
But when each mound that I climbed, there was an oil well, a gem, statements. I'm sorry, ma'am.
But and when the courts are inconsistent, though, who suffers? You find that it's the citizen suffers because you're going to go to Justice Fletcher today, and Justice Fletcher going to act this way, and then you go to justice in terms of the criminal law.
Yes.
And when there are areas that are so profound, the best thing is to have uniformity and consistency in approach. So
And if you go to Justice Togwell,
that is why
you
we had
might get-
sentencing guidelines for
I'm
some
sorry.
parts. So
You might
yes,
get
but
another-
people still have their
another decision.
own discretion. But when it comes down to, do you give credit in the face of the statutory minimum? That's a critical question because Parliament's law is brought into so we can't just be out there everybody on a frolic of his own if the question can be settled.
Yes.
That is all we say. You must settle some questions.
Yes.
It's not a matter of discretion, is it you're right or you're wrong sometimes.
Yes. Well, in the
But be that as it may, we got your sentence, because time is up on us. So this is the extent of your statement that you want us to have.
yes,
for
ma'am. Yes,
consideration.
ma'am. I'm spent
Yeah.
in relation
I don't think
to
we
that.
can trouble you much more.
Yes, I'm spent
on
in
that.
relation to that.
Yes.
And I must say that I think the court has already seen how rich a tapestry Worst is for a wealth of formulations that sum it up. And that was a significant thing for me. And that is why I say that one of the most important things that I got from it was the reconciliation possibility.
And
Because-
dead time is real time.
Dead time is real time. And I guess that is not out of sync with concepts of the afterlife.
Hope not.
That is,
You're looking
is
for credit,
really-
Mr. Fletcher?
but,
You're looking for credit?
Mr. Fletcher, just a question then. What impact, supposing this court were to find that really we ought to be giving credit for time spent when there are mandatory minimum, would there be any impact on persons who didn't get it in the past and are still serving? I mean, you can't help those who have left, but would there be any impact on those who are still serving?
I would really need to think about that. Not because I don't think there would be an impact, but because I wouldn't know what to do.
I think Georgian Rodok, if I may assist,
Yes.
gave some answer to that when they determined for those persons who were charged for murder and the wrong test was applied.
Yes.
Yes, that those who gone before, they just have to gone before. So the Privy Council, I think, just maybe my sister has not read that judgment,
Yes.
but that was the issue because they are saying for 30 years the Privy Council went in the wrong direction. So persons who have been convicted of murder that ought to have been considered for manslaughter, but there's nothing we can do. And they gave the principle with that. So you can go now, the court having dealt with it, we're functus to go back to go. So the Privy Council had addressed
Happily,
that
that is not within our remit at this time, so we may move on from that.
question. So that is basically it. Yeah.
See, I realize, my Lady Edwards, that in the scheme of things, you, my lady, are efficiency sensitive.
Extremely so, I'm afraid.
You should be close to the end now,
Yes, ma'am.
because who seem to say it all for you?
Yes, ma'am. The only other thing that I wish to say, ma'am, and I'm putting myself on the line in relation to this, is that the case of Duncan, I do not find it particularly useful to me. Case of Duncan. I do not find it particularly useful to me. It is surveying issues of the right way to bring a complaint, and I didn't find it particularly useful, bearing in mind the thrust of our submissions from yesterday.
Yeah.
Did I refer them to Virgo? And finally, ma'am, I wish to refer you to tab. You know what tab is? 5. Tab 5, Virgo, and another verse, Board of Management.
Which one is that?
Tab 5, ma'am, volume 1. I refer you to it. Virgo. Virgo.
Just before we go on from Duncan, the reason why Duncan was given to you is for the analogous reasoning that can be derived from it, but the court didn't want to look at it behind the back of counsel. So perhaps we can find what we think is interesting in it, but so we just let you know, because it was one of them referred
I'm
to.
entirely reconciled to
Right.
the superiority of your collective
Thank you.
acumen.
Thank you.
And I say straight that I couldn't see a way
That's why we use
that would
9.
help us.
Thank you. Yes.
Yes.
No, that is honest, you know.
Yes. Tab 5. Virgo and another verses several defendants is replete with discussions and quotations of the relevant. My Lady Edwards, you know, my lady, that I'm going to be very careful. I'm coming to paragraph 24. It's replete with pronouncements and learnings and understanding of this purposive approach of which I spoke earlier when it comes to the statutory interpretation and the reconciliation of which I spoke. And so I do not intend to, and I hope you go into it because it's just another water resource field. We have oil and we don't have water. I thank the panel very much for listening to me.
No, we just wanted to know, you cited Virgo simply for the benefit of the learning on the application of constitutional relief?
Yes, ma'am. The purposive approach to statutory interpretation. Yes.
So in relating all that you have said to the circumstances of the case you have before
Yes.
us now, what would you say in relation to the matter of this applicant?
Yeah, just refer much to my
In simpler language, what is it that you're asking the court to do? Or what order you're asking the court to make?
Thank you. Thank you.
In this case, yes. We want Mr. Moore to be given credit for time spent in pre-trial. And
2 years, 9 months?
yes, and why I put it that way, my Lady Williams,
Yes, you have to put it.
is that now we are at the door of several possible permutations of principles and decisions that can come out of this hearing. And the core, our core wish is that which I have just stated.
By whatever method the court
By
determines
whatever
is most
method
appropriate.
the court in its wisdom determines.
So at the end of the day, Mr. Fletcher, we are not saying, I'm not sure, I'm being maybe a devil's advocate here. You're not saying that the sentence is in and of itself excessive, the 15 years. We didn't see how the judge arrived at it. We don't know if he factored in the time. He just gave 15 because I think he said something about being merciful.
Yes.
So if the 15 years is not excessive, but you're saying he's entitled to credit.
Yes, ma'am.
So that is what I need to be sure, because your ground of appeal, as you rephrased it yesterday,
Yes, ma'am.
was that it was excessive because
Yes.
it included that amount.
Yes, ma'am.
Yeah, Junior
Yes,
beckons.
Yes, ma'am. So I remember once someone told me that when she went to her doctor said to her, "You must know when to ignore your doctor." I think I can
Very well.
very well.
Very
Thank you again.
Sorry.
Thought you didn't see.
I just want to be clear.
Please release me and let me go.
That's for somebody else. But in light of the question my sister asked, are you saying that it is not that the sentence may be manifestly excessive because credit has not been given, but you're saying that in any event credit should always be given?
Yes.
The failure to give credit has rendered. Yes. Because he ended up getting 17 years.
Of course. Yes. Of course. It's
Sorry,
not, it's not absolute in that there are some conditionalities that Kalachand and even the sentencing guidelines have in which allows for variation of the application of the credit. That is always in place. It is not absolute.
No, we understand that. I
Yes.
think we just want to make it clear what you're, based on your ground of appeal. So you must be saying that even though the minimum, you're not challenging the minimum in terms of it being an proportionate, proper sentence, but having arrived at the sentence, the judge, following the methodology,
Yes.
should have gone on now to credit him for time served.
Yes. Yes.
If he failed to take out that time that has been served, it renders the sentence manifestly excessive or even unjust, because
Yes.
at the end he end up getting close to 18 years
Yes.
for what was not intended,
Yes.
which would be higher than what he would have been penalized on
Yes.
at the first trial,
Yes.
where he got 15 years.
Yes, my lady.
So if the court finds that to be unjust,
Yes.
or there's a breach, if we follow the constitutional line
Act
and say
accordingly.
he was deprived of his liberty, not serving a sentence,
Yes.
and so on and so forth.
Yes.
So that is what we understand you to be saying.
Yes, ma'am.
Me? I think Jordan.
As we're saying here, even the sentence was lenient, he would still be entitled, based on
Yes.
your argument,
That is
to
my
the
point.
credit for the time
That is
served.
my
That is the law.
It's a term
That
of
is the-
years, and the arithmetical
Yeah.
computation had to be applied in a certain way,
Yes.
and it was not,
Regardless of where it ended.
regardless of where it ended.
I think we can release you now, Mr. Fletcher.
To my seat, ma'am.
And we thank you
Yes, ma'am.
very much,
And-
unless there's some other question.
Well, unless I'm giving notice, ma'am, that when my friends are called upon by you, my junior will respond to them if necessary.
He'll get his chance. Thank you. Okay, I think it's a convenient. What was that? Yes, we came in at roughly 10:30. At 10:30, we are now at 11:29. By the time we pack up, it should be 11:30, yes. We're going to take our break now. Yes. Thanks for the reminder. Wellness break. So, and I invite counsel and everyone in court to do the same. It's for your health. What they say, sitting down kills. Thank you. So we come back at 12 o'clock. Grateful. Oh, no, we should take 30 minutes.
Please sit.
Ready? Madam DPP? It's your time. You don't need a mic? What's for the... We know you don't.
I heard that, my lord. May it please you, my lords and my ladies, we will submit that in the particular case at bar, Cecil Moore and the King, we would submit, or dare I say, we would concede that the pre-trial remand of 2 years and 9 months, we had it at 2 years and 8, but we were using our records, but counsel for the applicant had it at 2 years and 9 months, so we will adopt that. That because there was no consideration given in light of the imposition of the minimum mandatory sentence, that it would be a breach of his constitutional right to liberty. And we would also submit that in respect of the Duncan and the Jokan and Attorney General of Trinidad and Tobago case from the Privy Council, certainly we on this side found it very helpful in seeking to craft a possible avenue or window through which this court could seek to make, just as it relates to the sentencing of Mr. Moore, to make his situation a just one by setting aside the sentence and making the adjustment downwards to account for the 2 years and 9 months. So we do not agree with my learned friend, Mr. Fletcher, that the Duncan case is not helpful. And in looking at the Duncan case,
which volume? I think yesterday we said volume 4A. It should have been volume 3A because 4 is the Attorney General's bundle, I think. So this should be attached to the DPPs. So it should really be 3A.
That's
so. The last bundle.
That is so.
I think it was placed at the back of it.
At the back of it. That is so, my lady. And I draw your attention to paragraph 33 and 34, because I must confess, my lady president, my ladies and my lords.
1 second, just give us some time to find what we are to find.
But I'm just filling the time while you're...
Okay. Paragraph, what is it?
33 and 34. That I can understand why in another case, this issue would have been deceptively simple. But as one went into it, it really was very troubling and very vexing and frustrating, because on this side, we are aware of the different streams of thought coming from this very Court of Appeal on the issue.
Sorry, Madam DPP,
Yes.
just to say for the record and to make it clear, yesterday when you came with your last set of submissions, you say that there was a change of position. So are we back at your original? Because your original was more or less in line, I think. Which,
Well, we are not quite
or you're
back
not
at
going to,
those
okay, so
submissions,
you're just
because
going to abandon these.
We agreed
Very well.
with the Attorney General's submissions
Submissions.
in respect of Worcest and Da Costa.
Okay, we
Hall.
just want to know how we treat with your submissions that you have, your bundles that we have. So we just set aside those and just relying on the authorities. We just need to know.
We are going to be expounding further on
I
it.
see.
In fact, I will confess that we also went ahead and we prepared even further submissions. We have prepared. After reading Duncan, we have
So
prepared further
that
submissions.
further submission should be the one you'd want to rest on, that bring you in alignment with the appellants to that extent. We just need to know
We are
what
not
our
in
records
total alignment. We are not
Okay.
in total alignment because we still give great respect to 42K
I see.
and we give great respect to the minimum mandatory sentence. So I don't know if I should.
We have to be clear, because when we are ready to ponder, we need to know what aspects of your submissions you are relying
Well,
on.
my lady, we will point out what paragraphs
Okay. All
we
right.
will still be
Thank you very much.
referring to. So, of course, just for clarity, as it relates to the background, the case for the prosecution,
Right.
the case for the defense, and the respondents, I'm looking at our original.
1 second. So that would be the furthest, because we don't have to
Yes.
use the original at all.
Well, we are not using the original.
Thank you.
What
So-
we did, we took some of the original and
I'll
we just put it in the what we call the further submission.
Or the further.
No,
That
the
one-
further submissions
okay.
that were
Filed on
filed
March.
on Friday.
Right.
Okay. So we are clear.
And we did this because we didn't want any confusion.
Because what we want to know is what we don't have to write, because what you're saying is contained in your written. So
Well, it
that's
would
why I
s-
ask you.
Well, it means then that perhaps the further submissions then should be also given to this court. And we do have copies. And you know, my lady president, my juniors said to me, Miss Llewellyn, although we're prepared this, we suspect certainly Mr. Justice Fraser is going to say, you have anything in writing? Let me have it. So
Mr.
perhaps
Fraser?
if we could be permitted.
Mr. Fraser doesn't deal with things in writing.
My
For
lady,
him to have it.
It is our experience.
He wants it to
In
be.
word.
Or well,
In word.
in
once we
word.
have it, once we have it. Once we
All
have
right, all right. Let me take us out of the misery. Are those submissions much shorter than the ones we had yesterday?
It's supposed to complement what we had before. They are slightly shorter, but it rests on Duncan.
Okay, very well. That should
So
help
we would
us.
call these our submissions relating to the Duncan case,
Very well.
basically.
You know, Madam DPP, because they put us out there in the public, I don't want anybody to think that this is the regular way we do things. We're taking submissions so late. But given the Duncan case, we know the court gave you that case. So
Well, that is so. We got it on Monday.
we would welcome your view on it. So to that extent,
Well,
the
my lady.
panel has agreed that we will take those.
Very well, my lady. And we are obliged.
Yeah, we did ask for your comment on it.
Well, those would encapsulate our comments.
Yeah, thank you very much. You may rest your feet until. No, I think you should stand. We are promoting standing. Yes.
So although it's entitled further submissions, but one could also say it's a Duncan submission.
Which of the original papers do we have? Takes out the background and all of that as you use.
Which one you handed
Is it the one filed on the master? That is what we need to be clear on.
Respondent's further submission. And it doesn't have any stamp on it.
So that's what we just got.
That is so.
But this one goes straight into the circumstances of the appeal and discuss Duncan.
That is so.
It must be to be aligned with the Friday one.
That is so, my lady. So you have what we filed on Friday, and then we have what we would call the Duncan submission.
This is further. Very well.
And again, I apologize, my lady. President, I was in a murder case until Friday afternoon, and I had to pivot.
Welcome to the club.
Being from the old school, I realized once it came to my attention on Wednesday, although I was in Portland, that certainly out of respect for this court, I would have to make myself available on Monday.
Thank you.
Okay.
Okay, so where are we now?
Well, I was just drawing your ladyship's attention
Oh, no, sorry. You had.
to paragraph
Paragraphs.
33 and 34 of the Duncan case. And I draw your attention to it because it is not that one does not know how important the fundamental right to a loss of liberty is, how important it is in terms of the Constitution. But looking at what was said here, paragraph 33, it was said that as the Attorney General accepts, the Court of Appeal failed to apply the law correctly. And may I take it that your ladyships and my lords, you are familiar with the circumstances surrounding Section 49(1). But in our view, the learning in respect of the reiteration of certain principles and the sharpening of these principles in the present day in terms of where the law has evolved as it relates to the constitutional rights, so a lot in terms of liberty and security, we thought that it is helpful. As it is true that as the Attorney General accepts, the Court of Appeal failed to apply the law correctly, but that is simply an example of an error in a particular case rather than an illustration of unfairness in the system as a whole. As the authorities reviewed above make clear, the fact that a judicial error has resulted in a person being imprisoned for a period when they should not have been does not in itself show that the legal system as a whole is unfair. Then in 34, we go directly to the last sentence. As explained in the authorities, the ability to appeal is the manner in which the legal system as a whole affords protection to the right to liberty and security of the person by due process in that type of situation, so far as concerns the need to ensure that the order of the court is quashed and deprived of legal force. And throughout the authority, it was littered with references to how critical the right of the citizen to liberty and security was. Now I turn to, just for clarity, in respect of my submissions that were filed on Friday, to show what we are relying on, certainly from paragraph 1, the background, which I will not go into to the circumstances of this case, which my learned friend, Mr. Fletcher, went into. It outlines also the case for the prosecution at paragraph 6, the case for the defense, and then we went into our submissions. Now, my Lady President, I was made aware by my team that the case of the Queen against MacDonald had previously been made available to all sides. And we took the view that along with MacDonald, the case of Worst, both cases from the Supreme Court from Canada, that because it discussed those two provisions, that it could be distinguished from the case at bar. Although we saw the learning, we saw the principles, we saw the spirit behind the principles that were
Sorry, what two
enunciated.
provisions? Because you're moving from constitutional rights
In
or is
respect
it
of
legal statutory provisions?
the statutory provision where in determining the sentence to be imposed on a person convicted of an offense, a court may take into account any time spent in custody by the person as a result of the offense. And I think there was a section 3, thank you, my lady, 344A of the Criminal Code, which indicated the minimum mandatory sentence for armed robbery. I think it was 4 years, and it with the use of a gun. And it was quite clear that when one looked at the reasoning, that the contextual framework had to do with reconciling, to use my learned friend's word, the two statutory provisions in a harmonious way in the interest of justice. And I believe, from what I read there, it was certainly done. That was certainly achieved. However, in the Cecil matter, in the Jamaican scheme, where we only have the minimum mandatory provision, I believe it is section 20B of the Offense Against the Person Act, and we have section 42K and 42L of the Criminal Justice Administration Act on one side, and on the other side, we have common law, which has not been codified. And that is the dilemma that this august body that I appear before will be seeking to deal with in a way that the interests of justice will be served, and most importantly, being guardians of the Constitution, that the constitutional imperatives surrounding every citizen of this country will be protected, whilst respecting the separation of powers doctrine and the policy imperative that was behind the promulgation of Section 20 of the Offences Against the Person Act.
The last part missed me about the imperative, sorry.
The imperative, the
No, just
policy
the
imperative.
sentence, that the justice is served on the constitutional rights.
And that being the guardians of the Constitution, that this court is obliged to make a judgment and a decision in this matter which will safeguard the constitutional rights or imperatives surrounding every citizen of this country, whilst giving due regard and respect to the doctrine of the separation of powers, since this court has indicated...
That's a long sentence. That's a paragraph or a sentence.
Very well. I'm sorry. Let me cut it down.
Yes.
So we could have the full stop at the constitutional imperatives surrounding the rights of citizens. This has to be balanced. It is my humble submission. On the other side, with the regard or respect for the policy imperatives from the executive that would have, at paragraph 7 in the Tafari Morrison case, which is
Citation.
K. Tafari Morrison 2023 UK PC, page 14, and it is K in our bundle of authorities.
Thanks.
And at paragraph 7, the Privy Council there, and your, my lords and my ladies, would be very aware of that particular case, the facts, where an accused male who perpetrated an act of wounding and illegal possession of firearm and robbery when he was 16 was found guilty and on appeal all the way up to the Privy Council. The appeal was dismissed, and most importantly, the mandatory minimum sentence was deemed to be constitutional. But at paragraph 7, the Privy Council gave due regard to the policy which was outlined by counsel for the appellant. And it's done in a very simple way, which is why I would commend it to your ladyships and my lords. In the following remarks about the offenses, the crime of illegal possession of firearm and ammunition and wounding with intent are serious charges. And they are, in fact, they go beyond being serious. They are heinous charges, ones which claim the society of Jamaica, and they have had a ruinous and damaging effect on this country. So, looking back at my first further submissions, so that would be the imperative of the executive policy. Oh, I see. At tab K, my lady. Tab K of our bundle. Tab K is Morrison. Oh, I see. Yes. In my further submissions, well, at paragraph 12, we spoke about the mandatory minimum. And then at paragraph 13, we touched on the constitutionality, which was of section 20 of the Offences Against the Person Act, which was upheld in the Tafari Morrison case. And I will say, my lady, that like the Attorney General's chambers, we had taken the view, which is outlined in our further submissions at paragraph 13 and paragraph 14, that section 42K. Is my lady Edwards with me? Yes, very well. Paragraph 13. My lady President, I'm trying to be methodical, so I'm trying to deal with those before I go on to the Duncan submissions.
Okay, we follow.
But I adverted to the Duncan what was said, just to rivet our minds on how, remind myself of how critical the right to liberty and safety is in the Constitution. So back at
Security of the
paragraph
person.
13.
Sorry, is it security of the person?
I'm sorry?
Security of the person?
Yes. Yes, baby.
Yes.
So in our submissions filed on Friday, we went through, like the Attorney General's chambers in their submissions, section 42K, and we have outlined it there. And just for ease of reference, I would just quickly read section 42K, which of the Criminal Justice Administration Act, provides an avenue by which the risk of a sentence being manifestly excessive or unjust as a result of the imposition of the statutory minimum sentence may be averted if used. And it provides that where a defendant has been tried and convicted of an offense that is punishable by a prescribed minimum penalty, and the court determines that having regard to the circumstances of the particular case, it would be manifestly excessive and unjust to sentence the defendant to the prescribed minimum penalty for which the offense is punishable, the court shall A. Sentence the defendant to the prescribed minimum penalty, and B. Issue to the defendant a certificate so as to allow the defendant to seek leave to appeal to a judge of the Court of Appeal against his sentence. And 2, subsection 2, a certificate issued to a defendant under subsection 1 shall outline the following, namely A, that the defendant has been sentenced to the prescribed minimum penalty for the offense. And I'm reading it out because I know there are law students here. I hope I'm allowed as well. Okay, very well. So I don't have to go any further.
You just need to highlight what you want from me.
Okay. And that the certificate must outline that where the court decides that having regard to the circumstances of the particular case, it would be manifestly unjust for the defendant to be sentenced to the prescribed minimum penalty for which the offense is punishable, and stating the reasons therefore. And C, the sentence that the court would have imposed on the defendant had there been no prescribed minimum penalty in relation to the offense. And then it outlines thereafter that where the certificate is issued by the sentencing court or the sentencing judge pursuant to the previous subsection, this would act as a trigger to a judge of the Court of Appeal who, if having reviewed the particular documentation, agrees with the decision of the sentencing judge, if that judge of the Court of Appeal determines that there are compelling reasons that would render it manifestly excessive and unjust to sentence the defendant to the prescribed minimum penalty, the judge of the Court of Appeal may impose on the defendant a sentence that is below the prescribed penalty, and be notwithstanding the provisions of the Parole Act specify the period not being less than 2/3 of the sentence imposed
Madam
by him.
GPP,
Yes.
so as Councillor said, my brain tends to be expeditious. So let me see if I can jump ahead of you based on where I see you're going so that we can just delineate quickly. So I start with A. You agree that the time spent on pre-remand, not taken into account, is unjust and unconstitutional. So you agree with that. Your second point is that any consideration by this court must take that into consideration but balance it against the imperatives of the executive, which has been recognized in the Privy Council Interfering Morrison. Your now suggestion is that that balancing exercise can be done by virtue of the legislative provisions in 42K. You're saying it provides an avenue which this court could use to carry out that balancing act that you have. Well, basically the court, but it's here now, so this court would have to recognize it. That this is the ticket. Okay? This is the ticket. I soon get there. This is the ticket which would provide the balancing act. So what you're saying is that where a court gets a case in the process of sentencing and realizing that the person before them to be sentenced is one who has spent time in pre-remand, they ought, should, must, and I'm using those terms depending on what
The circumstances
the
are.
circumstances, provide a certificate.
That is so, my lady.
So remember, I say that which is a good idea. I have no problem with it. It's an excellent idea, actually. But one, this case has no certificate, the one before. B, what happens if the judge below fails to do so, even where there is an imperative? Because it's fine, this court may say that this should be the approach, in which case the courts below may very well find them be bound by it. But you know that there's always going to be that one or that two
Well, the
that
court
does not.
Duncan speaks about error.
Yes,
Error.
but if you read Duncan, you'll see that that error does not automatically
affect the fairness of the system.
Exactly. So in this individual case does not have a certificate. What then do we do? Other than just to say courts must use the certificate. But what about this man who has no certificate?
But, my lady, this is why I made sure to indicate to you that we found Duncan helpful. I was simply developing my
Duncan
point
doesn't
because
help.
I believe to my learned friend, Mr. Fletcher, the point was made by one of your sisters on the body that, looking at the worst case, I think my learned friend was really urging the court looking at the worst case, although the framework is different, that Parliament seemed only to have been focusing on that is the impression I got, on the mandatory minimum. Parliament did not go ahead and promulgate a similar section which would have codified Kalashant, right, and made it expressly relatable to a mandatory minimum.
Is it a circumstances where, say for instance, if that is the kind of balancing act that this court could use, would the court then be in a position to say, send it back for the judge to reconsider whether in the light of those circumstances, unjust, excessive, having spent time in remand, should a certificate be issued? Or
well, my lady, that has exercised our minds in respect of one of the options that this court may have. Because I will further develop that if one is going to take the Duncan line, we believe that that is a more appropriate scenario where if your my ladies and my lads would wish to look at the narrow issue of the not considering the pretrial remand as being a breach of the constitutional rights, then we would, and we have it here in our document, ultimately, I'm jumping ahead, indicate that it would be open to you to then substitute the sentence, because the fact that you are the guardian of the constitutions, and once you determine that it has been a breach of the constitutional right, then it would leave you open to act, and we have put that in our further submissions.
Right what would have gone wrong down below.
That is so.
But my concern...
But my lady president, if I may just be allowed, it does not mean, and we would invite this court, when you do come to write your judgment, to remind, because I think a lot of people are not even aware of it, that 42K is redundant. If it is that there is a scenario where to write what is going to be unjust by not properly considering the pretrial remand, 42K can't be used.
But I have a problem with that. It's the same discussion we had yesterday. If we take that route, what it would mean, because I thought I was allowing you to do what you had to do by going to 42K because you told us that that is a prelude to Duncan. But if you accept, as you seem to have accepted, that engage in these matters is the constitutional right to liberty, which ought not to be breached unless demonstrably justified in a free and democratic society. And you're saying in Mr. Moore's case, it would not have been, given the fact that his conviction was quashed and all that. How do you juxtapose, how do you put how do you balance constitution with legislation if you accept that when it comes down to your constitutional right, and if there's an infringement, Parliament's law has to give way in terms of the application of it. Not that we're saying this section should be set aside, but to apply to this particular case.
But
so I am trying to
but
understand.
with respect, my lady,
yes,
as was said in Duncan,
yes,
the fact that the judge may have, because we believe the judge erred.
in not.
First of all,
sorry.
the judge erred in not going
May I
through
just hear what it-
going through the methodology, a la Misha Clement.
Yes.
The judge did err because the judge ought to have gone through that formulation so that the judge would have been fully informed in respect of which way to go in assessing the justice of the
One
sentence
second.
that
But
he is
remember
going to
this,
give.
I'm sorry, remember I noticed the Crown's argument that it was lenient, but I kept saying to you this case is different for the fact it was on a retrial. He got 15 years in the first trial. So what you'd say, you'd have to assess to see whether he fall. Even if he had fallen above 15, he would have been duty bound to give the 15 because it couldn't exceed what he got in the first trial. And bearing in mind, he got 15 years in the first trial, and he was on remand for almost awaiting 2 years, let us say, awaiting his appeal. But once you accept, as you have done, and that is what sort of bowled me over, in this particular case, because we have to apply the law to each appellant.
That is so, my lady.
If you accept that his right to liberty was engaged and it is breached, how does 42K factor in such a scenario by saying that the judge, there was no, I'm trying to follow you because one second, if it is breached, that's a breach that should be obvious to the Supreme Court judge, which means if he failed to give effect, then, so I'm just trying to grapple with 42K.
I want to say it with respect because errors happen, there can be oversight, or this may have been a situation where if there was a sentencing hearing, neither side, whether the prosecution or the defense in their submission, picked it up.
In 2016, that wasn't being done. I'm
well,
sorry.
that is so.
Because
that is so.
Misha Clement wasn't out
that
yet.
Is so.
So people were not in this approach, methodology to sentencing, as you can see. So we're not going to blame the judge there. He was doing it in accordance with the old practice.
But, my lady, this is why I read out. This is why I read out 42K. Because speaking for myself, sometimes you are doing this thing so much and you look at it. But sometimes it's just like when you're dealing with Turnbull. We were having a conversation yesterday with other prosecutors that sometimes we cite Turnbull and we forget that Turnbull's fact pattern is very, very powerful. So I was going through 42K to remind myself and perhaps to just further advise the court that what it speaks to is the whole question of whether the sentence would be manifestly excessive and unjust.
Yes, but just a moment, Madam DPP.
Yes, lady.
I'm getting the sense, and I just need you to correct me. It's as if you are suggesting that 42K should be used to protect the constitutional right? Is that what you're suggesting?
I'm not saying that. I'm saying that there are several routes that ultimately will have the same effect. What is the effect? What is the mischief that we are interested in making sure does not occur? The mischief is that there is some credit given as it relates to pre-trial remand.
Yes,
so
but why would you need 42K if it is a constitutional right to which you are entitled?
Because
why would you need to use that?
If it is, and we believe that the mandatory minimum sentence is constitutional, then the first judicial body that would interact with the rights of the accused would be the sentencing judge. So it is a sentencing judge who would have done the calculation and would have recognized that given the pretrial remand, if I shut my mind to everything else, including that, and just say, my hands are tied as it relates to the mandatory minimum, then that is where the judge would err. Because the judge, granted it's the Court of Appeal that is the guardian of the Constitution.
The court.
The Supreme Court, very well. Very well. The court is the guardian of the Constitution. The judge would be entitled to look at all the options available to make sure that the mischief that could occur is prevented.
But two choices. He could give it himself by recognizing to give effect to the constitutional breach, right? Reduce the deduct it from the sentence he arrived at and give it there. Or he could say, well, my hands are tied. But if he says his hands are tied, then he has the 42K route to send it on to the Court of Appeal. That's what you must be saying.
That is what I'm saying. And
if he fails to do that?
Because circumstances differ. And as your ladyship has said, each case has to be looked at according to its own circumstances. Because, for example, in this case, it is our view, looking at the case law precedents, that taken by itself, that issue, if you added 3 years then to the 15 years, it would be manifestly excessive based on the authorities. In fact, may I say, being the humble prosecutor, that he could have been indicted for attempted murder, given the circumstances of this case. And if it had been attempted murder, then, in fact, 15 years might have been deemed to be too low.
Madam,
But
sorry to interrupt
Yes,
you.
yes.
I hear the reasoning. My challenge, though, in respect of relying on Section 42K to vindicate a constitutional right, is that what you're really saying is that the sentencing court, in and of itself, will not have the power to properly do so, and you're going to have to rely on an appellate process to ensure that justice is ultimately done. And I have a fundamental difficulty with that, because if the sentencing court recognizes that in the particular circumstance of the case, you should go below the mandatory minimum, then in the context of a constitutional right, it seems to me difficult to require that process to take place in an appellate court.
I hear what your lordship is saying, but I suppose I could say, having been around perhaps too long in the courts, judges may have different factors depending on the particular case before them as to why they would wish to go in terms of the A direction as opposed to the B direction.
If I could just continue on that, because I think Section 42K is useful in the sense that there may be a range of circumstances.
That is so.
But my difficulty is something as fundamental as the fact that you are due whatever time you've already spent in pre-sentence remand. You should not need to go to a higher court to vindicate that. You know, there are other circumstances which may be open to debate, but that shouldn't be, in my humble view.
I think as a legal purist, I can understand what your lordship is saying, but I think in practical realities, I don't see why both cannot exist. Why both cannot exist side by side.
And once a court recognizes that what we are faced with is a constitutional right of the citizen, why would a judge need to invoke the appellate process for the appellate process to, and when it falls within your own powers and jurisdiction to do so? Just like how we say the mandatory minimum provision must yield to the Constitution in its application to a particular matter, 42K should yield to, because it is a statutory provision being confronted or to be balanced with the Constitution. So the judge could say, although, remember too, the question arises whether 42K deals with anything to do with taking out time served, or the sentence that you think you arrived at after the methodology is applied. And I think that is what the case law says, that you do your starting point, restart, and everything, and what you're left with, you declare the sentence, give a reason for your sentence, and then you go on to check to see now if the person had spent time in custody. The time in custody is not a gift we are giving. It is to recognize that the person's liberty was restrained while they were still presumed innocent until they were proved or pleaded guilty. So why a court who is the guardian, the Supreme Court no less, and the Supreme Court more than any other, because that is the original jurisdiction for the vindication of constitutional rights. A judge, as a sentencing judge, looks at proportionality. And proportionality falls within the ambit of the Constitution. So why do you need, in the circumstances where it is clear, and if this court were to say credit is to be given in circumstances where it might go under, still send it up here? That is what we are here about, what we do. So I am still trying to understand why 42K should arise in the context of this case, where you have admitted that in your view, the man's constitutional rights
But my lady,
is breached.
if I may be permitted to play devil's advocate, had the learned trial judge done the computation and issued a certificate believing that when he does the computation, it would have been manifestly unjust, especially in light of the fact that a first trial had already occurred, where you had 15 years, and that he would know that he could not, that the mandatory sentence plus the pre-trial, granted, yes, he could, take in your view, he could say, okay, I'm the guardian of the Constitution, I am going to subtract the 2 years and 9 months. But what I'm trying to get at is that it would not have been wrong. It would not have been a wrong route for him to take if he preferred to use 42K under the fact that it would have been manifestly unjust on 2 counts. One, the fact that the 15 years.
Yeah, but this is, to my mind, in the context of this case, I see what you're looking at. You're looking down the road
And
as
at
to
the
the
utility,
options that
generally.
and the utility that can be what can be made, the
In
use
fact,
that can be made of
yes.
42K. But I'm saying if it is settled on constitutional grounds that you give credit for time served, and that is regardless of where it end up, why would a court of law now have to resort, having recognized that the Constitution is engaged, it is breached in this case, to give a certificate for it to come to the Court of Appeal for a point of law to employ lawyers? Does that really make sense? Because all the judge has to do, as the guardian of the Constitution in whose bosom resides that duty to ensure that the citizens' rights are upheld. Remember, no organ of the state should breach that right. So if the judge, having recognized that there's a breach of the Constitution, but nonetheless sentenced, we are now caught in the same web where we are breaching. So I am of the view that this 42K, I accept. It can be an avenue if a judge believes that that is so. But if the court lays down what we are here to decide, do we accept as a point of law, having regard to the constitutional rights of the Charter of Rights, especially the rights to liberty and security of the person, that someone is entitled to his time served regardless of whether it goes below the minimum in a particular case? Cecil cannot be used. Every case has to be determined on its own facts. But we are not here for academic purposes right now. We are here to determine Cecil and if there is a principle of law that emanates from here, which binds the lower courts, then they will see how to utilize it in a case before them. But 42K, the discourse on 42K is just missing me
Milady,
in the context of
if I may
case.
play devil's advocate again. Play devil's advocate, because I'm not a constitutional expert. But if I play devil's advocate, would there be any difference if the mandatory minimum sentence was 5 years. The accused has come to the Court of Appeal having been in custody when you take his pre-trial remand. Say it was 2 years extra. But he's coming to the Court of Appeal in his 6th year. So he has already served the 5 years. And he's going on to, if I may be permitted, going on to serve technically the other 2 by virtue of the computation. Would it be different in terms of when the breach of his constitutional rights occurred? Would the breach occur pre-trial at the time of sentencing, or is it that you're going to look down the road to say, if it is that I don't address this now, down the road, when he comes to the 5th year and he's going into the 6th with the computation by the prison authorities, that is when the breach occurs, as opposed to before. I'm just playing devil's advocate. I wonder if I'm making myself
Because
clear.
we have had several court cases here. Well, I allow my colleague to answer since I don't want to.
I'm just playing devil's advocate.
There are other constitutional remedies, other constitutional breaches that may come into play at some point. Would there not be? Because if he has already finished his sentence, this court could order his release, but he would still be entitled to perhaps redress for the delay aspect.
Well, we go
of
back
the
to the
matter.
Melanie Tapper line of cases and
That's
Evan
not the
Jack
case.
and all
So
those
I
which
don't
we have
think,
referred
but
to.
that is why I'm wondering, Madam Director, when Mr. Fletcher yesterday spoke about game changing, that is why I thought that we are all agreed that whatever we decide here was to be binding on the courts below. That once we have found, if we so find, that the constitutional right is such that once you have demonstrated, that is why it was important for me to decide, to hear whether it was we're saying the sentence was excessive or whether we're saying it's justice that he was still entitled to. So it is important to set out the structure, as you say, arrive at a figure, regardless of what. It could have been 16 years.
Or 18.
And you still have to take off those 2 years, which would take it below the minimum. In those circumstances, depending on what we find, it could still be done in the courts below without coming here. A person could be sentenced to a life imprisonment for any other offense. And whatever that offense is, you're still entitled, after the proper calculation is demonstrated, you're still entitled to. That is why the question of whether you call it a credit for time served, some people say we shouldn't, whether you just call it a matter of reducing the sentence, but it's a recognition that you have already served, been in prison for a portion of this time that I am now sentencing you to. You're entitled to it. So therefore, regardless of where it was, once it ends up below the statutory minimum, what we're trying to determine is whether the courts below can do that without resorting to 42K.
Yes. And Ms. Llewellyn, we, Madam Director, we have seen it fit to embark on this query with the involvement of everyone, because there are many cases that we have had here where persons await trial over 5 years or even 10 years. And when they are to be convicted, when they are sentenced now, if you were to say it, to give them a certain amount, if you're going to give them 20 years, let us say, which they are entitled to as a sentence, and you're saying to take off the 10, it's going to drop below the minimum 15. It means that we can only give them, and we have had a case like that, we only could give them 5 discounted, so that person would end up still serving 20 years. And that is how the Canadians and all the other places have looked at it, because as the Canadians say, and I don't mind how they look at it, they're saying at the end of the day, if we take off the 2 years from Mr. Moore's sentence here, he will still serve 15 years in prison, because he was in prison at Tower Street awaiting this. So this is why we're here. And once you recognize that there is an engagement of the Constitution, that is a litmus test for anything else, be it the parliamentary law or the act of the court or the executive or any organ of the state. Once the Constitution is engaged, the court's power is triggered, regardless of where we sit. Let us look at the parish court. Suppose it was a case of a man in custody, because sometimes you really think you can't give them bail. And you restrain them for all 3 years. The parish court maximum sentence is 3 years. When it comes to sentencing that person, you're going to give him 3 years now as a sentence. But when you look at it in effect, you would have served 6 years awaiting trial while you are presumed to be innocent. Presumption of innocence is another guarantee of the Constitution.
Well,
so
we are certainly aware
I am
of
just
that
saying to
every
you,
day.
once you put the Constitution in the equation, there comes the game changer. So how does 42K helps? And the Court of Appeal is saying, even if we say, okay, the judge could have given it and help us out here, but remember that time, the time spent wasn't part of our jurisprudence. It came in Misha Clement later on in 2016.
And to be fair to the Parliament, and that I'm
judge.
holding any brief for them,
Yes.
at that time it was not. So
Exactly.
they did and must have considered that there needed to have been an avenue if there was going to be a situation of the minimum mandatory sentence being manifestly unjust or excessive.
But time
and
spent
that is
wasn't
what,
one of it.
And that is what.
Sorry, time spent wasn't
Well, it
that.
was not.
Right.
It was not, because the law at that time was not as developed as it is now. So certainly we recognize this, to the extent that I even said to my colleagues that perhaps coming from this, I would be minded to write to the powers that be to make a recommendation that we put in an equivalent to what is in the Canadian code. And I still plan to do it,
Yes.
because I think it would be the final thing to make everything very tidy, so that if you have a recognition by the executive and the Parliament that in fitting now with where the law has evolved, it would be good if statutorily you codify what was said in Canada.
But why can't
and
we
make
do
sure
it? Why can't we do it constitutionally and let Parliament catch up by doing it
With the
legislatively?
greatest of respect, I'm going to leave it to my learned friend from the Attorney General's chambers. I come here in peace, and I do know that the executive and policy, the executive would say they are elected, and then you have the judiciary, and
Yes,
that there is
but-
an uneasy tension
No,
where
but
both sides have to work together.
no,
in the
but
public
but
interest.
Madam,
So I'm not going
Madam,
there,
no,
my lady.
no, you're
Edward.
going to go there. You know why you're going to go there? Because you have stood there and you have admitted that this is basically a constitutional issue, where the rights of the citizen has been
The
breached.
liberty.
And if that is so, and you have also agreed that the courts are the guardian of the Constitution, why then, as guardian of the Constitution, we are not entitled to grant a constitutional remedy where there has been a breach? If Parliament, as a separate but equal arm, wishes to recognize whatever it is that this court has recognized as a guardian and do its part on its side to put that in legislation, it doesn't mean that there's any tension. It means that there is harmony. That's what it means. So we'd have proceeded harmoniously by Parliament recognizing that the courts have done the correct and right thing. Well, correct and right is the same thing, but the correct and constitutional thing.
And Madam DPP, I know today is Peace Day, but if you go back to some of the analysis in Worst, it has wider systemic application, because one of the points made, I think, in this paragraph 42,
Systemic.
is that if you don't have fairness in the way it's applied, then it benefits offenders who are worst offenders, because
Yes.
they can get the credit, but a first-time offender or
Yes,
somebody
it
who
is
was on
made
bail
that point.
would
Who
not
was
get
on
that,
bail.
that benefit. So it's
Equality of treatment.
under the equality of treatment principle, it really seems to me strange that you're going to have to require a separate process in another court to vindicate a basic right which we all agree exists.
And I just add for finality, to the best of my knowledge, and I don't know if it is law yet because I don't deal with bails, But when Parliament decides that for some offences there shall be no bail, when the persons are retained, unless the court, whatever, but the court exercises its discretion and say no bail for how many, and give our system where people are not coming up to trial till maybe all 5, 10, 8 years. How do we treat with that dead time, which as the Canadian says real time, and it's real time in our prisons, because most of the cases, South Africa, all of them, they look at the prison conditions, and that is what the Privy Council said in Calajan. Mauritius must look at its local conditions in terms of its prison conditions. And if our prison conditions are not pristine, and I won't say a word on that, then that is another thing. It's not that you're sending the person in custody to sit in a room like the Pegasus. So it's not only deprivation of liberty, it is holding them in conditions that another provision of the Constitution is engaged, that there must be dignity and humanity to everything we do. So we are here about the Constitution. And that is why, just like in the Supreme Court of Canada, they had 7 judges, we have to carry the entire court with us, because we don't want 3 people down there saying he's not to get, and another 3 don't agree. The weight of the court must come down, whether we dissent or not. And then Parliament gets the judgment and see what we have to say.
My lady, if you were to ask my colleagues, they would tell you I was saying to them that this Court of Appeal has to be commended, because what you are doing by sitting as you are is making sure that the confidence of the public is enhanced, because you are making sure that where we had 1 or 2 streams of thought coming from the Court of Appeal, that you are making sure that there will be certainty in one position, and also not only certainty, but you are making sure that the very high threshold of consistency in the application of the law in this particular area is maintained.
Thank
and
you.
may I say, my lady
Thanks for
President,
recognizing.
well, we did, because I've been around a long time. Too long.
I won't say it shows. I'll say it sounds that way, Madam
This is it.
Deputy.
But this is why we on this side, because we know that we are ministers of justice, and part of my function is to make sure that you look at the public interest and the interest of all persons, including the accused.
Very well.
So we will complete on Thursday morning.
And then we'll hear from the learned Attorney General.
The government's attorney. Actually, we have on this side, we have been teasing him, because when your ladyship yesterday said the government side,
the state,
we all looked at each other, and in our conversations we said, well, we are ministers of justice, but you are the government's attorney.
Thank you, Madam.
Very well. May it please you.
So, 1 second, please. Thank you very much. I think we have made much headway today, and I don't expect to hear too much more from the DPP.
Well, your leadership has our submission.
And we have
the
all
further submission.
Which we'll have electronically as well, right?
And you have been of great help for the concession. We thought it was over, but we
your
move on.
Your leadership knows Paul and Vanessa learning things out. So, you know, you have to be decisive, one way or the other.
Wait till, wait.
The evolution of the law. Constitution. Yes, but
All right, promptly at 9:30 to Thursday. And remember, tomorrow is, and there's a reason for Ash Wednesday. Look back at that one. Repent. Sackcloth and ashes. Thank you. On that note, have a good afternoon.